evening. I'm Professor Paula Colby-Clements, and I'm going to talk to you a little bit about hiring and firing employees. Now, I want you to know I have a lot of information on the screens, on the slides. I'm not going to talk to all of it. I'm going to hit the highlights. As you know, you can scan the code and get the slides, so some of that information is just there as a reference for you. So first thing I want to do is set the stage and say small businesses, when they hire or fire employees, they're going to run into some potential issues. And these could be, I hire somebody that doesn't fit the culture, or I fail to properly vet someone, and we'll talk about negligent hiring. I could be embroiled in a discrimination lawsuit. I could not follow legal procedures like wage law. There's all kinds of ways you can get in trouble. So the first thing you need to understand is you want to understand the laws so that you can develop policies and procedures that are consistently employed and adhered to keep you out of trouble. Now, before we get into the statutory schemes, what I want you to know is they generally say that employees are protected from discrimination when it comes to terms and conditions of employment. So the first thing I want you to understand is what that means. Terms and conditions of employment deals with every contact that you have with someone in the hiring process, in terms of when they're an employee and when you separate from them. So all those points of contact can cause problems because those are terms and conditions. So let's talk about Title VII. Title VII is the major federal statutory scheme that prohibits employment discrimination, and it says if you are working for somebody, you are protected from being discriminated against, from being harassed or retaliated against because of your inclusion in a protected class. That would be race, color, religion, sex, and national origin. The courts have decided that sex under that statute means gender expression, gender identity, sexual orientation, and I put gender in pregnancy because any immutable trait that is associated with a gender is going to be protected under there as well. Now, this law doesn't apply to independent contractors, but it does apply to every employer who has 15 employees or more. And there's more. You have the statute that protects against age discrimination, so you can't discriminate against somebody who's 40 or older. You have the Americans with Disabilities Act Amendment Act that says you can't discriminate against somebody because of their disabled status. And the other thing I want you to know is employers are regularly held accountable under all these statutory schemes. It's much rarer for your managers, your supervisors, the employees who might treat coworkers badly to become personally liable, unless they're way outside the scope of their employment. And so you as the business are going to be liable for the actions of all those people generally. Now, again, that's 15 employees or more in Massachusetts. We have a corresponding statutory scheme that applies to all businesses that have 6 employees or more. And that's codified at Mass General Laws, Chapter 151B. And under subsection 1, we protect against employment discrimination if you are discriminating based on race, color, religious creed, national origin, sex. We include gender identity and sexual orientation in the plain language of the statute. Subsection 1B protects against age, 40 or older, just like the federal law. Subsection 16 protects against disability, just like those other federal statutory schemes. So in Massachusetts, it's all in one place. Now, there are several theories that plaintiffs will bring when they're trying to prove discrimination. They can bring a disparate treatment claim. They can base it on harassment, negligence, disparate impact. They can prove that you've engaged in a pattern or practice. They can prove that you failed to accommodate. They can prove that you retaliated for asserting a right. And then there's a theory called the cat's paw theory that you should know about, where you might have some sort of an agent that engages in discrimination and those actions get attributed to you. The first one I want to talk about is disparate treatment. I'm going to spend more time on this because this is really the primary way that people bring claims. And this is really the most obvious and blatant form of discrimination that there is. And essentially, it says, hey, you have treated me differently. You have subjected me to some deleterious action because of my inclusion in one of these protected classifications. So the easiest example, let's say you have a rule that says, I'm not going to hire Muslims in my business. Well, you've engaged in discrimination based on religion, and that's pretty obvious, right? So a plaintiff that's alleging disparate treatment, the thing you need to know is they have to prove that you intended to discriminate, that their motivation for taking that action against you was because you were part of that class. They can do this two ways. One, they can prove with direct evidence of discrimination, and that is exactly what it sounds like. If I have a manager of my business that says, I'm not hiring older people. I want to hire all employees in their 20s because, hey, older people, they just get too tired at the end of the day. So I'm going to hire everybody in their 20s. You've now engaged in discrimination based on age, right? That's direct. If somebody says that, that's direct. You can imagine, not very often are people going to throw themselves under the bus that way. They're much more sophisticated in that. So oftentimes there isn't direct evidence. And so the second way is the indirect method. And this is where plaintiffs can bring together all kinds of circumstantial evidence that if it went to a jury would more likely than not find that your motivation was indeed because they were a member of the suspect class. So the next thing you have to understand is how these cases progress. And we start with the shifting burden framework. This is the McDonnell-Douglas shifting burden framework. And we use this for the Massachusetts statutes, and they also use it under all the federal statutes. So what happens is the plaintiff has to establish a prima facie case. So the first thing they have to show is if they're saying, take that over 40 example, you didn't hire me because I was over 40. You have to prove you're a member of a protected class. Pretty easy to do. In terms of hiring, they have to show that they were qualified for and applied for an available position. In terms of the firing, they have to show they were qualified for the position that they held and you took some action against them. In addition, they have to show, despite being qualified, in terms of hiring, that they're rejected, or if we're talking about firing, that you fired them and you didn't treat other similarly situated people the same that are outside your classification. If you decide not to hire somebody, and you are then still out there looking for people with the same exact qualifications that you have the qualifications of the person you rejected, they've made out their prima facie case. So the idea here is it's not hard to do. It's not really hard to establish a prima facie case. And then what happens is something that's rather unique in the law, because the plaintiff generally always has the burden of proof. Here, once they meet that prima facie case, that burden actually shifts over to you as the employer. And you now have to prove it. You actually have to produce admissible evidence that shows that the reason you took the action was a legitimate non-discriminatory reason. So if you don't understand the law and you don't have good policies and you don't have good practices to document things, it is going to be very hard at this stage to produce that admissible evidence to rebut that prima facie case. And if you don't, you lose at this stage. Now, if you do, the burden shifts back to the plaintiff to produce evidence that rebuts that motivation and shows that the reason that you're offering, those legitimate reasons, are actually a pretext to cover up the discrimination. If that happens, the suit's not necessarily over. You're headed towards trial, but you created a triable issue. But really important to be able to get over this second shift here. The burden is going to be on you to produce that evidence. Okay, so let's talk about hiring. So as we know, we're going to hire. We put out ads, right? We try to cast a wide net. We want to attract enough pool of qualified candidates so that we can figure out who we want to hire, right? Typical ads state things like job title, job qualifications. Do you need a degree? Do you have to have so many years of experience? Do you have certain skills that you're going to require? And it might also have salary and benefit information. Most important thing to remember as a general rule, all qualifications or characteristics stated in the ad really must be job related. Now, keep this in mind. That ad itself, as you're looking for the hires, can create some problems. So you want to do certain things. You want to include an equal employment opportunity statement. You want to avoid discriminatory language. You don't want to run an ad that says we're looking for waitresses or stewardesses when those have a certain gender sort of stereotype, because then it might intimate that you're excluding certain members of the population, right? You want to avoid an age discrimination claim by saying we're looking for young college students, because now you're discriminating against people that are older, right? you got to make sure you make the ad available to the disabled. So for example, if you have an ad and you say, hey, the way you respond is you need to pick up the phone and call this number to get more information, then you should have a telecommunication device for the deaf so that you're not excluding that population. Recruiting online, this is where we get into disparate impact claims, and the difference there, just briefly, is that if you're going to be sued for disparate impact, it means that you have a policy or practice, or you've done something that is facially neutral, like on its face, it doesn't look like it's discriminatory, but it has the impact, even if you didn't intend for it to be, it has the impact of excluding a subset of the population that's protected. So for example, if you have an ad and all you do is recruiting online, and it turns out that that impacts a segment of the population that's a protected class that doesn't have access, say, to computers, you've now opened yourself up to a claim for discrimination. Okay, so now you've had the ad, you're going to start asking people to fill out applications. Let's talk about those applications. Some of this might not apply to all businesses, so this is here just for people to look at if it's relevant, but there are things that you want to do. There are laws that say that you have to allow people to put volunteer work on there. There are laws about criminal background inquiries. There's a lie detector statute law. So that's there really for you to look at after without me running through those, but the idea is there are statutory schemes that do guide you on what should go in that application. You also want to make sure that your applications seek to solicit, again, relevant job information. So you want to put that EEOC disclaimer on there. Lots of times employers will put employment at will statements. You don't want to create a contractual or even quasi-contractual relationship, so we put that disclaimer there. Put a statement there that the information on the application is true and complete. Make them sign it. Imagine you go through the whole process, you hire someone, and then they're working for you and it's a real problem. And you want to fire them and you have policies and practices, progressive disciplines, things of that nature, but you find out that they had lied on the application. That's a fireable offense, and you're going to not necessarily run afoul of any of these problems because they signed that everything in there was true. You want to have them sign and know that you're going to be checking their references, calling their prior places of employment, things of that nature. Maybe you're going to ask them whether you can do a criminal background check. Just they know that you're going to verify all that information. And then you really will have, I'll talk about this in a minute, but you have a duty to verify that information. If you're going to have any testing requirements during the application process or before you hire, you want to put that on the application, because what you don't want is you're about to move some people along in the process, and let's say someone's disabled and suddenly you spring on them, hey, we have these testing requirements. It may look like you put a roadblock in front of somebody just because, let's say, they were disabled. So if there's requirements that are job related, put it right on the application so that they know. And a statement of compliance with the Immigration Reform and Control Act, you would want to put that on there. Okay, now they've submitted the application, you're going to bring them in. You're going to talk to them. Let's talk about interviewing. One thing that you need to know, and this is important, the courts are going to assume that every question you ask in the hiring process, you're using those answers to make a decision about employment. So imagine that you bring someone in, you say, oh, they look really nervous, so let me just make some small talk and talk to them, and you start saying, oh, do you have kids? What's your religion? Or anything that you think is just casual. But it turns out you don't hire that person, and now they come back and say, oh, they asked me my religion during the hiring process, right? Because the courts are going to assume if you ask the question, you're using those answers somehow in the hiring process. You want to make sure that your questions are all related to whether that person is qualified for the job. There are some things that you really don't want to ask. You don't want to ask people about their age. You don't want to ask about national origin or citizenship, but you are allowed to ask somebody if they can provide proof of work authorization. That's okay. Questions that might create a discrimination claim for gender, again, those child rearing questions, things of that nature you want to stay away from. But it's okay if somebody starts bringing it up in the interview. Oh, well, I have 2 kids, they're in preschool. And let's say that there's heavy travel requirements for the job. It's okay to say to them, well, hey, 50% of the job is travel, so tell me how you're going to manage that. That's okay to do. Don't ask questions about religion. We're giving you a link to the Guide to Criminal Records in Employment and Housing because there's certain things about criminal convictions that you can ask and can't ask. And again, you really want to stay away from those disability questions, although you should know that it is okay to ask somebody how they will perform the essential functions of the job. All of that is going to be okay. I want to talk quickly about negligent hiring, because now I've talked a lot about all the things you should do in every step of the process. And in particular, that application process and your due diligence before you hire someone. There is a theory called negligent hiring, because the law says that you have a duty to protect your employees, your customers, clients, and visitors from injuries caused by employees that you know or should know pose a risk of harm to others. And so if you don't call and check references, if you don't call other employers that this person had, and let's say you hire someone and they're violent in the workplace and they cause somebody injury, and had you just called the last employer, you might have found out they were let go because they were violent in that workplace. Because you didn't do that due diligence, you could have found to breach your duty to the employee, the customer, or whoever gets hurt. And workplace injuries and workplace violence is actually pretty prominent in the United States today. So you want to make sure that you're doing that due diligence to avoid this, right? So have those processes, make sure you check the application, make sure you run the references, make sure you check with prior employers. Now, one last piece that I bet most people never talk about. Think about who the applicant is. What are you going to do about unsolicited resumes and job inquiries, including walk-ins and call-ins? Now, one thing I want you to know is I'm not saying that you can't hire somebody that just walks in, hand you a resume, and you think they're the greatest person ever. However, the failure to establish and follow a policy on how to deal with them can result in discrimination charges if you selectively take some people's resume and decide to hire, but selectively don't take others because they're not part of an ongoing process. It's just something to think about, to have a policy and procedure on. Other thing I want you to know, an employer must keep job applications and hiring documents related to non-hires for 1 year after. And for your hired employees, you have to keep all those documents from 3 years after separation. Okay, you've hired somebody, you've done your due diligence, you think you've done everything you need to do to have the perfect employee, and it just doesn't work out, right? So now you got to fire somebody. Well, letting go somebody creates their own problems, right? So we'll talk a little bit about this. Firing someone too hastily or without taking proper steps can lead to an uncomfortable situation. It can lead to legal issues that can endanger your business, right? We all know, or I think most people know, that most employers are at will. They're not contract employees, right? So what does that mean? That you can fire them at any time, for any reason, no reason, with or without notice, right? As long as it's not an illegal reason. And what I tell my students is the at-will doctrine is like a piece of Swiss cheese. It has so many holes in it that it's almost non-existent as a doctrine, right? So you want to make sure that you document the firing process and what led up to that firing process. Now, say you decide, I'm going to have a policy of progressive discipline. That'll really protect me, right? I'm going to give you a warning. I'm going to give you a second warning. Third strike, you're out. And then you have somebody that's so problematic, you think to yourself, I just don't have the time or the inclination to go through that progressive discipline. I know what I'll do. I will just make their life so miserable that they'll want to leave. And she's already shaking her head. Don't do that. That's right, because there's something called constructive discharge. And if, objectively speaking, the average worker would not tolerate the conditions that you're creating for them, and that person quits, it is treated as if you fired them, and you can be sued for that. So be aware of that. Again, the McDonnell-Douglas shifting burden standard operates here as well. So when you get to that portion after they have the prima facie, established the prima facie case, you're going to want documentation on the firing so that you can produce that evidence and shift the burden back. Here's some of the top indicators of a legal motive for firing: sudden threats of termination or termination for performance problems when there was never a performance problem in the past, absence of contemporaneous documentation, post hoc attempts to document performance problems. When I have clients that come to me and say, hey, I think I was wrongfully terminated, first thing I say, go request your employment record. If you get a request for an employment record, you have 5 days to get that to them. Usually, what I've seen in the past is you get the employment record, You end up filing at MCAD, Mass Commission Against Discrimination, and they suddenly produce an employment record that has all these things in there that didn't exist when the employee asked for the record upon separation. You start adding stuff to that record later, even if it's legit, it's going to look like you're covering up an illegal motive. So you want to watch out for post hoc attempts to document. And, obviously failure to establish policies, having a policy that you're going to do something one way, but then you don't treat everybody the same, all things that are going to be problematic for you. Best for you also to sit and consult with employees. This seems to be the thing that's most uncomfortable. Employers don't do it all the time, but honestly, if you have an employee that's problematic, one of the best ways to avoid problems is just sit down and talk to them. Maybe they hate the job. Maybe they're hoping you fire them, right? If you can sit down and have a conversation with them, maybe you can go to separation and work it out and you never have a problem, right? The other thing is, you fire somebody too hastily, you got to think about the effect that has on the rest of the employees. If boss just comes in one day and starts firing people, that changes the culture, right? So talking things through is really important, and we want to encourage that. But finally, if you do have to separate, you really want to make sure you have a separation agreement. Things in the separation agreement should cover things like severance payments, protecting their reputation during the job search, mutual releases, having an enforcement agent in there so that if they breach that, if you have some confidentiality information in there, they breach it, you can sue on that. And then I do want to mention complying with Massachusetts wage law. We gave you the site here. Remember, when you separate from an employee, the day you let them go, you are required to pay them their earned wages. And vacation time, earned vacation time is earned wages. So let's just say that you hire somebody who automatically say, you get 2 weeks vacation. And it's not something where they earn a day, a month, or whatever. And then a month later, you're firing them. They get that vacation time, and you're going to pay that out the day they leave, along with any earned wages at the time. So I think that's it for me. Thank you, guys. My contact information is here.